Holland Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello, everyone, and welcome back to the latest episode of our AI and Legal Professional Privilege podcast. Today's episode is a special one, part 2 of my discussion with James Shiel, Principal Associate from Mills & Reeve in the UK, in which we discuss how AI is impacting legal professional privilege, focusing on how the issue is being approached in Australia as compared with the United Kingdom. For those who tuned in to part 1 of my discussion with James, we canvassed the current position in the UK, specifically a recent decision of the Immigration Upper Tribunal, as well as judicial consideration out of Australia, specifically commentary from the Federal Circuit and Family Court of Australia, which have provided some comments on AI and legal professional privilege in this space. With our discussion with respect to those recent decisions in mind, it's interesting to consider the language used by each jurisdiction and how they differ. By way of quick refresher, in Australia, the Federal Circuit and Family Court has observed that there is a risk associated with entering documents into AI, which may waive privilege. So they've used words such as risk and may. In comparison, noting this only represents a few paragraphs in one judgment, but still very important. The UK position includes strong messaging, including to specifically reference the difference in inputting information into something like ChatGPT as compared to Microsoft Copilot. Again, this difference between open and closed AI. Now let's see what James thinks about the significant language used by the courts. And also let's move to discuss the extent to which the judiciary in the UK has considered the terminology of open versus closed AI and what's to come in this regard. Over to you, James.
Yes, I think the first thing to say is, whilst the language used by the court in the decision that I reference appears on the face of it to be stronger than what you're seeing in Australia, I think the message is effectively the same. And it's important to recognise what the court didn't do in that case. It didn't actually make a finding that privilege had been waived. It was effectively an observation, an additional commentary. And this all took place in effect in a case where the court was dealing with procedural issues, including fake citations and hallucinations and the use of potentially models in the production of court documents. So it was dealing with that and this in the round. So that probably reflects why the judiciary's commentary is quite strong on the face of it. I think in particular, whilst I think using AI public models, the risk is obvious, isn't it? But there are strong reasons to speculate that uploading material, privileged material, into a public tool may not automatically amount to a waiver of privilege. And I expect that the judiciary in England will take a more nuanced, fact-specific exercise before making a finding of privilege. And it will also need to consider areas around intention, accessibility of material that's been uploaded into these third-party providers, public policy concerns, and also fairness before finding that privilege as actually being waived. And like you said, Lauren, the court's likely to need to take a closer look at some of the terminology and assumptions that fall within the UK Upper Tribunal's decisions. And big questions do arise, right? And for example, and not exclusively, one thing the decision exposes is that we're all using shorthand, like public AI, closed AI, enterprise AI, without really interrogating what those labels actually mean. So there's no uniform guidance in the UK about those terms. The Upper Tribunal, as you mentioned, appears to make a distinction that ChatGPT would be a public AI model, whereas Copilot would be an example of a closed source AI tool. But we still need to be very careful, even with that commentary, when using these terms or concluding whether or not certain products fall within the category of public versus closed AI. And the real question isn't how the product is marketed, labeled, or whether it's free or a low-cost option to use. It's, for example, whether by using it, you're giving confidential information to a third party, and whether you still control that information, and whether it meets the thresholds around privilege, as we've discussed. And another issue that the judgment really throws up is whether it's actually right to say that putting advice into a public AI tool automatically means it's placed on the internet in the public domain, or whether in reality that kind of conclusion should depend on a much more fact-specific analysis. And that naturally leads to one other question. If a public AI tool is configured so that it doesn't learn from user inputs, does that change the privilege analysis at all? And if it does, where are the boundaries for lawyers to be able to advise their clients on?
Yeah, that's very interesting. And I really think that comes back to our ability to define or understand this use of AI, because at the moment, and I think this touches on something we were speaking about recently, James, is that how do we combat this in practice? And I think we were speaking about how the UK judiciary has started to, in some capacities, amend claim forms to recommend that they be filled out in court to actually address a complainant or a claimant's or a party's AI usage. And that perhaps is the first step toward addressing this. Is that something, can you tell us about that and how that's shaping up in the UK?
Yeah, so following the decision that I've talked about, again, in that context of where they're dealing with these sorts of procedural issues, and in the case where they're seeing citations which are in court documents but then cannot be found by the judges, the upper tribunal made the decision to amend its judicial review claim form so that legal representatives must expressly certify that any authority they cite, first of all, exists, can be located, and actually supports the proposition relied upon in the court documents. And that's dealt with in the judgment itself in, I believe, paragraph 9 of that judgment. But what that's not is a general civil procedural wide requirement across all English courts, but it's a very clear signal of judicial expectation, particularly in response, as I mentioned before, to AI generated hallucinated authorities. And what we have had recently is the Civil Justice Council recently published an interim report and consultation on the use of AI in preparing court documents. And one of the recommendations in this area is effectively a proposal that, provided the statement of case, so such as pleading, such as claim forms, bears the name of the legal representative who's taking professional responsibility for that statement of case, there's no need for any further rules relating to statements of case produced with the assistance of artificial intelligence. But its alternative proposal, which it's asking for comments on, would be to require a specific declaration to make clear if the legal representative has used AI in the preparation of a statement of case at all. So that's where we are in this jurisdiction at the moment.
Yeah, so that's very interesting, because I think, again, we in Australia are perhaps a touch more mild in that we don't have a consistent mandatory requirement, obviously, nor do you, but we haven't taken that sort of extra step as a result of a decision. In Victoria, the Supreme Court's guidelines do encourage self-represented litigants to include a statement about the AI tool that they use or they rely upon in any AI generated materials to be filed with the court. But similarly, at a different level, tribunal does require a level of disclosure, and only a level of disclosure rather than full disclosure. So again, there's a recommendation and there's starting to be a trend toward that, but none appear to go as far as the UK prescribes as part of its claim form, nor is it uniform across the jurisdictions or across the states. It's just it's starting to move forward. And again, it'll be interesting to see the extent to which the recommendations around that in Victoria and more broadly in Australia do start moving that dial. Really, change is coming and change is consistent. So we have to watch this space as to see what extent to which this is adopted in Australia, and whether we're looking to the UK to see whether the claim forms or things are to be amended in that way. And do you see any other sorts of change coming in the UK, James? Or do you maintain that you think it will be a sort of case by case, more nuanced assessment? Or is it really too early to say in circumstances where the judiciary has only really started grappling with this point?
I think it's too early to say in some respects. It's that point around the judiciary are grappling with this now, and we can see that from the case. The technology is changing. But if we do see change, it's going to be a gradual form, patchwork and piecemeal based on the issues that either come to the court and for judges to deal with, or alternatively via the methods that I think both of our respective jurisdictions are dealing with at the moment, which is specific bodies looking at amendments to civil procedure rules and consulting with practitioners to work out what is the best way, which effectively is around making sure that it's an efficient use of the court's time. There is a concern, for example, if you ask for, in statements of case, for the use of AI to be disclosed on each and every occasion, is that going to lead to satellite disputes and litigation and waste more of the court's time, for example? And there's lots of different areas as well in relation to producing court documents. And one of the particular areas that's been looked at the moment is statements of case, as I mentioned, but also witness statements, expert reports, disclosure, there's lots of different areas for the court to have to grapple with and practitioners to grapple with. So I expect it will be on a piecemeal by piecemeal basis. I assume probably very similar to what you're dealing with in Australia too.
Yes, and as I've reiterated a couple of times, it appears that we're in Australia quite focused on the self-represented litigant in this regard and it sort of is the patchwork that you've referenced in that these are the people often that these instances are coming up in. So we're dealing with them as they come up and trying to address those issues in the regulations or in the recommendations. Whereas I do think we'll have to get to a point where we're looking ahead at next steps rather than trying to address what's already happening, which obviously things like this Law Reform Commission report has done, because as you've referenced, it is a report that's spoken to multiple stakeholders over multiple different legal fields. But yes, I do think in Australia we are trying to look further ahead, whereas in some instances so far in the judiciary we're assessing what self-represented litigants, what's actually happened so far. So it will be, it is very much a situation of watch this space, because I think to be able to move forward in a coherent fashion, we need to really get across a lot of this ever-changing field, which is hard to do and keep on top of. But exactly as we've just discussed, what sort of real life situations then are we encountering when we come across this? Because this sort of leads us to consider what is worrying us when it comes to AI and worrying litigators when it comes to AI and privilege. Now, that's a very open-ended question because it is a minefield, and things that we don't understand or we're able to control does offset our duty to maintain confidentiality. But what are you seeing there as a particular worry in your day-to-day practice, James, for English litigators?
Yeah, and I think if I actually just take one step back just to address your previous point, I think the attitude of the court here anyway is that the responsible use of artificial intelligence is a welcome step. And I think that's by practitioners, but also by litigants in person. Those people are unrepresented. The judiciary, my broad sense is they think it's a positive step forward. And from my perspective, I don't have any war stories to tell in terms of where I've seen things go wrong with AI and privilege, but it is an area that we're advising on more and more frequently now. And the scenarios that worry English litigators are very ordinary ones. Clients pasting legal advice into ChatGPT to quote unquote understand it better. Employees potentially of our clients summarizing disputes or regulatory issues by public AI or any AI tool, or as we saw in the upper integration tribunal case, lawyers uploading correspondence into public tools for effectively drafting assistance. But yeah, I'll pause there because I believe you have some additional examples that you might be able to share with us as well.
Yes, well, funnily enough, as we've spoken about on earlier sessions, what triggered Katie Moore and myself to start speaking about this issue was exactly an instance, a very, very day-to-day instance that we've encountered where a client received an advice and then wanted to better understand some of the portions of that advice and thought to upload it to ChatGPT. So to translate or to get some clarity around a couple of portions of that advice. And then from there, it flowed of our consideration of to what extent does that waive privilege. Nothing too revolutionary in that regard, but it does open the door for real consideration around questions like, were they instructed by their lawyer to do it? And again, this is something that was considered in the aforementioned US case. And that actually decision, I won't show my hand, but that decision actually turned on whether or not counsel had instructed or they'd acted on their own behalf. So I wonder whether Australia or the UK are going to go down that sort of route. But in our instance, there was no instruction at all, obviously, by practitioners to so put this information into ChatGPT. And so we immediately cautioned that sort of activity would waive privilege. But then similarly, what flowed from that was our discussion of if, for example, discovery were to occur and an opposing party learns that that were to say be uploaded, are they entitled to demand access to that information and any comments that flow from that, any chatbot information, any subsequent documents that are created based on that? And it really opened the door to our investigation there. So I haven't seen many horror stories, hopefully, gladly, but one such consideration opens the door to how things can go wrong and are going wrong in other jurisdictions.
Yeah, absolutely. And I think what we are seeing here predominantly in practice is, and I think the same applies to a lot of our clients as well, is that they are using enterprise or closed models when they're using AI and in their day-to-day business. But what I would add is closed AI systems aren't necessarily the silver bullet, and people shouldn't think necessarily by using them, that's it, and they're protected by privilege. And as we've touched on before, many organizations now use enterprise AI systems that operate within secure, segregated environments. And it is thought, and I think it is right to have this view, that it reduces the risk by using those tools if they're configured in a way which means that the provider can't use those inputs for model training and can't access or disclose the client data. However, the mere use of a closed system doesn't by itself confer or protect privilege, and that communication must still satisfy the test of legal advice or litigation privilege in England. And so, for example, if an employee uses an internal AI assistant to analyze legal issues unconnected, but not going to a lawyer within the business or externally, there's a real risk that the output, it looks like legal advice, but it potentially isn't. And that advice isn't, well, called it advice, that output isn't likely to be legally privileged. And even if an underlying privileged document never escapes the system, there is a risk around logs, screenshots, outputs, local copies, or other documents such as transcriptions, which are taken from AI note takers, that they might surface in investigations or disclosure exercises. And secondary evidence such as this might be admissible, and privilege might be lost if confidentiality has already been compromised.
Exactly the point. And so really appropriate confidentiality obligations must remain in place between a user's organization or a user and the provider themselves. And really, obviously, practitioners should obtain informed consent from clients, but a practitioner, or more broadly, it's the firm, must be careful to fully understand the terms and conditions of the relevant tool and make sure that all those questions have been ticked off and satisfied, because exactly, it's not as black and white at all as public or open means that it's open to the world, and closed means that it is just that, it is closed. Because really the question is how closed is closed and how extensive is the output and the like. So it's not nearly as black and white, and nor would one expect it to be in such an ever-changing position. But yes, so if we, with that in mind, if people still are wanting to upload privileged or confidential information, there are things that practitioners should perhaps ask themselves or pause to consider, key points or questions. And obviously, now this is quite an obvious point, but a threshold question would be, do you even need to consider this or worry about this? Not everything that you're going to have prepared or work with in a work setting, perhaps as a practitioner, is confidential or is privileged, as everyone would know. For example, preparing slides for a presentation or something, that's not information you have to be concerned about. And so in that regard, AI would be your friend in that assistance. But then it needs to be considered about whether the terms of engagement with a specific client, or say a panel agreement or otherwise, actually allows for you to use AI. Because I can speak from experience, I have some clients in which they don't feel comfortable with the use of AI. And so obviously that's a pre-existing condition and we've adhered to that. So if we get past those sorts of initial threshold questions, then James, can you give us some practical takeaways for someone to consider perhaps before uploading confidential information?
Yeah, absolutely. So until the court's pronounced definitively, the safest course of action is very clear, at least in this jurisdiction, which is keep privileged and confidential material out of public AI chatbots entirely, and effectively just treat them as unsecure channels for now. Some additional practical takeaway points. Firstly, establish strict internal AI policies, and organizations effectively should adopt clear policies that prohibit employees from using public AI tools, from any potentially privilege related materials, but also potentially broader than that. And I know, for example, some organizations go as far as to block public AI tools, so they're just not even accessible by their employees on their work devices. And training should emphasize the issues around confidentiality, privilege, and also verifying what information and outputs are generated from models, whatever models they're using, whether that be public or closed. The second takeaway is use enterprise AI solutions only. if they have robust safeguards to them. So before you deploying any internal AI tool, ensure that there's contractual guarantees that prevent the provider from retaining or using the data for training. Make sure that data is stored solely within the organization's environment, and ensure that there's things around access controls as well. Thirdly, organizations should anticipate disclosure and accuracy challenges. So parties may increasingly seek disclosure of prompts, logs, and AI usage records. And therefore, it's also really important, as I mentioned before, and you mentioned as well, Lauren, that any outputs relied upon, whether that be in a legal setting or a non-legal setting, that they're independently verified. And finally, I think there is a potential upside for us as lawyers here. There's a real opportunity for us to add value, clear advice, better summaries, and just helping clients navigate away from necessarily just pulling that AI chatbot lever as the first port of call when they receive legal advice.
Exactly. And I know, at least with our circumstances, James, and tell me if this is the same with you, we are really encouraging clients, if in doubt in any capacity, please feel free to pick up the phone. I know it's an obvious concept, but rather than irrevocably change the relationship between the both practitioner and the client, but also between that communication and its confidentiality, pick up the phone and have a conversation. This, from our perspective, this can be a sort of 5-minute discussion to quickly speak through any initial concerns, and it will hopefully offset or alleviate any issues that some would try to ask, perhaps an AI tool to clarify instead. And I think that's something that all lawyers probably think is quite obvious, but I do encourage clients to pick up the phone rather than to really change the nature of the relationship there.
Exactly. And these models, they work on the information that they're given and that they have access to. So there might be wider context which, as lawyers, that we put into what we thought about when we're drafting our advice, which not necessarily that the AI chatbots would also pick up. So it's always better to pick up the phone or email or whatever it is, but we can answer those questions probably a lot clearer and quicker than an AI model could do. Yeah, I completely agree with that advice.
Exactly. So really the takeaway is, if there's any doubt about an AI tool's capability to maintain confidentiality or to be used with respect to communications or documentation, don't input it into the tool. Don't take the risk. Pick up the phone, speak to us. Don't run the gauntlet in that capacity.
Yeah, absolutely. And I was just going to add, Lauren, I think the other point that comes away from this, organizations should think about what their AI governance looks like. And that's including in terms of creating how legal advice runs through the business and potentially how AI material is used, but also just broader privilege. What we've been talking about today is a really small subset of the AI question for our clients and organizations. So we can help clients with putting in place those frameworks as to how they make really sometimes complicated decisions about how they deploy and best make the use of efficiency gains that can be made through AI, but in an efficient and responsible way.
Exactly. And yes, I agree. And really, as we know, there's a lot to talk about with this topic, as we can see, and it's ever changing and ever evolving. And there's not one overarching position in either Australia or the UK. The current position will surely shift and become more expansive in the coming months. And we'll continue to monitor the landscape both in Australia and the UK. And we do look forward to speaking with you, James, again, perhaps about this evolving topic and how it shifts. We'll also be, as I foreshadowed earlier, we'll also be speaking with other international colleagues in episodes to come to compare other jurisdictions. And again, perhaps that will have some impact on how either Australia or the United Kingdom looks to adopt next steps. So thank you everyone for listening today. James, thank you very much for sharing your insights on the state of AI and legal professional privilege in the UK and comparing that to our position in Australia. Thank you very much, James.
You're very welcome. Thank you for having me. Thank you, everybody, for listening. And I feel like Lauren and myself could have continued and talked for a lot longer, but very happy to come back in the future if we do have a more definitive judgment or some more information that would be useful to share with you.
Wonderful. We'd love to have you, James. So as always, listeners, please get in touch with us if you have any questions. You can find our details on our Hall & Wilcox website. You'll also be able to find James's details on the podcast information when it's released and connect with us on LinkedIn. If you enjoyed today's episode, then please rate, review, or subscribe to our podcast wherever you get your podcasts. Thank you very much and have a lovely day.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.